Miss Wilson, perhaps you'd like to explain military contract precedent to the court? Judge Garrison smirked, expecting to humiliate this simple woman in a veteran's jacket. The courtroom tensed as she stood. What happened next left everyone speechless. Margaret Wilson stared at the stack of legal documents on her kitchen table, a cup of lukewarm coffee forgotten at her elbow. At 60, her face carried the quiet dignity of someone who had weathered life's storms without losing her composure. Her silver-streaked hair was pulled back in a practical bun, her simple Veterans Association jacket worn but neat, much like the modest apartment she called home. "Grandma, are you sure about this?" Sarah, her 18-year-old granddaughter, leaned against the doorframe, concern etched on her young face. Maggie looked up, offering a smile that didn't quite reach her eyes. "Not really, but what choice do I have?" The letter from Patriot Defense Systems sat prominently atop the pile, a military security contractor claiming she had breached their service contract and owed over $15,000 in penalties, money she simply didn't have. "You could just pay what they're asking," Sarah suggested half-heartedly, knowing the impossibility of her words. Maggie shook her head. "That would mean emptying my savings for your military academy tuition. Besides," she pushed back on the table, determination straightening her spine, "they're wrong. I fulfilled every term of that contract." What Sarah didn't fully understand was how much her grandmother had sacrificed. 20 years ago, Maggie had been a dedicated specialist in the Army's Judge Advocate General's corps with dreams of becoming a military attorney. Her deployment to Iraq and subsequent injury had forced her to medically retire, derailing her legal career aspirations. The corner of her small living room told that story. Stacks of military law books purchased secondhand, legal journals borrowed from the Veterans Affairs Library, online courses completed late at night after long shifts at the VA office where she now worked as a coordinator. For years, she had absorbed military legal knowledge like a sponge, finding comfort in the structure and logic of the law even as life remained stubbornly chaotic. "I'll handle this," she said more to herself than to Sarah. "I have to." The next morning, Maggie dressed in her most professional outfit, her Veterans Association jacket over a crisp white blouse and navy slacks. She carefully packed her documents into a worn leather briefcase that had been a gift from her commanding officer when she first began JAG training. As she walked to the bus stop, Maggie mentally rehearsed her arguments. Patriot Defense was claiming she had failed to meet notification requirements when canceling their home security service, but she had records, emails, certified letters, even recorded phone calls. She was prepared. What she wasn't prepared for was Judge Robert Garrison. The Jefferson County Courthouse stood imposing against the morning sky, its stone facade weathered by decades of rain and sun. Maggie paused at the bottom of the wide steps, taking a deep breath to steady herself. Inside, her footsteps echoed on the marble floor as she navigated the hallways, following signs to Courtroom 7. When she pushed open the heavy wooden doors, the scene that greeted her was intimidating in its formality. Rich mahogany paneling lined the walls, the American flag standing proudly near the judge's bench. The room was already filling with lawyers in crisp suits, their confidence as apparent as their expensive attire. Maggie took a seat at the table marked for defendants, feeling painfully out of place. Across the aisle, two attorneys from Patriot Defense arranged their documents with practice efficiency, their matching charcoal suits and leather portfolios screaming corporate power. "All rise." The bailiff's voice rang out as the side door opened. Judge Robert Garrison entered the courtroom with the self-assured stride of a man accustomed to command. At 65, he cut an impressive figure. Silver hair perfectly styled, his black robe settling around him like armor. His reputation had preceded him. A retired Army general before his 25 years on a bench had earned him the nickname the Garrison Guillotine for his swift and often merciless judgments. As he settled into his chair, the judge's gaze swept across the room, pausing momentarily when he noticed Maggie sitting alone at the defense table. A slight frown crossed his features before he turned his attention to the docket. "First case, Patriot Defense Systems versus Wilson," he announced, his voice carrying the slight southern drawl of a native Virginian. "Counsel, please identify yourselves for the record." The Patriot attorney stood in unison. "Jonathan Mercer and Lisa Chun for the plaintiff, Your Honor," When the judge turned his attention to Maggie, his eyebrows raised expectantly. "Margaret Wilson, representing myself, Your Honor," she said, proud that her voice remained steady despite the butterflies in her stomach. Judge Garrison looked at her over his reading glasses, making no attempt to hide his skepticism. "Pro se, Mrs. Wilson? Are you certain that's wise?" "Yes, Your Honor," Maggie replied simply. The judge sighed, the sound clearly communicating his disapproval. "Very well. Mr. Mercer, you may present your case." As the Patriot attorney launched into his opening statement, Maggie felt the weight of Judge Garrison's dismissive gaze. She understood his unspoken message. This would be quick, and it wouldn't end well for her. Jonathan Mercer moved with the polished confidence of someone who had never doubted his place in the world. His voice carried through the courtroom as he laid out Patriot's case. "Your Honor, this is a straightforward breach of contract. Mrs. Wilson entered into a binding agreement with our client for home security services. The terms clearly state that cancellation requires written notice 60 days in advance with confirmation of receipt. Mrs. Wilson failed to provide such notice, continued to use our services, and now refuses to pay the accumulated fees and contractually stipulated penalties." Maggie listened carefully, taking notes on a legal pad. Her handwriting was neat and precise, each point organized with the methodical attention of someone who had trained herself to think like a military attorney, even if she didn't have the credentials to prove it. When Mercer finished, Judge Garrison turned to her. "Mrs. Wilson, your response?" Maggie stood, smoothing her jacket with steady hands. "Your Honor, I did provide proper notice in accordance with the contract. I have documentation showing multiple attempts to cancel the service within the required time frame." She began distributing copies of her evidence, emails, certified mail receipts, and phone records. Her organization was impeccable, each document labeled and highlighted at relevant passages. Furthermore, she continued, "I would direct the court's attention to Section 4.3 of the contract, which states that notice is considered delivered upon sending, not upon confirmation of receipt. The clause Mr. Mercer referenced applies only to disputes regarding service quality, not to cancellations." A flicker of surprise crossed Judge Garrison's face, quickly masked by a frown. "Mrs. Wilson, are you claiming to be familiar with contract law?" "I'm familiar with this contract, Your Honor," she replied evenly. "I've studied it carefully." The judge studied her for a moment before turning to the Patriot attorneys. "Mr. Mercer, your response to Mrs. Wilson's interpretation of Section 4.3? Mercer appeared slightly flustered as he shuffled through his documents. "Your Honor, our position is that Section 4.3 must be read in conjunction with Appendix B, which modifies the notice requirements for all communications." "May I address that point, Your Honor?" Maggie asked. Judge Garrison gestured for her to proceed, his expression a mixture of curiosity and skepticism. "Appendix B was added to the contract after the initial signing date," Maggie explained, pointing to timestamps on the documents. "Under the doctrine of contra profundum, ambiguities in contracts are interpreted against the drafter, especially when modifications are made unilaterally without clear notification." The courtroom fell silent as Judge Garrison's eyebrows shot up in genuine surprise. "Mrs. Wilson," Judge Garrison's voice had a new edge to it. "Where exactly did you learn about contra profundum?" The question hung in the air, a thinly veiled challenge. Several attorneys seated in the gallery exchanged glances. The Patriot lawyers whispered urgently to each other. Maggie stood her ground, her posture straight, but not defiant. "During my service in the Judge Advocate General's Corps, Your Honor, the principle is well established in military contract disputes, similar to how it's applied in Mastrobano versus Shearson Lehman Hutton." Judge Garrison leaned forward, his fingertips pressed together. "Indeed it is. And can you tell the court what the Supreme Court held in that case?" It was a test, one designed to expose her as an amateur who had memorized a few legal terms without understanding their context. Maggie could feel the weight of expectation in the room, the collective assumption that she would stumble. "Yes, Your Honor," she replied calmly. "The Supreme Court held that when a contract contains both an arbitration clause and a choice of law provision, the ambiguity must be resolved in favor of the party who did not draft the contract. The court emphasized that ambiguous terms must be construed against the drafter to protect the party with less bargaining power. A ripple of murmurs spread through the courtroom. Judge Garrison's expression remained neutral, but his posture had changed subtly. He was now truly looking at her, reassessing. "And you believe that principle applies here?" he asked, his tone less dismissive than before. "I do, Your Honor," Maggie responded. "Patriot added Appendix B 6 months after I signed the initial contract. They sent it as part of a 47-page service update email. Under Rossman versus Fleet Bank, unilateral modifications to material terms require clear and conspicuous disclosure." Jonathan Mercer rose quickly. "Your Honor, Rossman dealt with credit card agreements, not security services. The case isn't applicable here." Maggie didn't miss a beat. "With respect, Mr. Mercer, while Rossman did involve credit cards, the principle has been applied more broadly in consumer contracts, as in Barr versus Chase Bank and Douglas v. U.S. District Court. Both cases affirm that unilateral modifications to essential terms must be clearly communicated, regardless of specific service being provided." Judge Garrison's eyes narrowed slightly. The courtroom had grown so quiet you could hear the old wall clock ticking. The judge studied Maggie for a long moment before turning to Mercer. "Mr. Mercer, did Patriot specifically highlight the changes to the notice provisions when Appendix B was distributed?" Mercer shifted uncomfortably. "The entire document was sent to Mrs. Wilson, Your Honor. It was her responsibility to review it." "That wasn't my question," Judge Garrison replied, his tone sharper. "Was Mrs. Wilson specifically informed that the cancellation terms were being modified?" "I would need to check our records on that point, Your Honor." Judge Garrison nodded slowly. "I suggest you do that." He turned back to Maggie. "Mrs. Wilson, you've clearly done your homework on contract law, but I'm curious, what is your background exactly?" Maggie felt every eye in the courtroom on her. "I served in the Judge Advocate General's Corps for 8 years, Your Honor. I was training to become a military attorney when I was injured during my deployment to Iraq. Medical retirement prevented me from completing my legal education, but I've continued my study of military and civilian law independently since then." Something flickered across the judge's face. Recognition, perhaps, or reassessment. He nodded once, then addressed both parties. "I think we need to examine these documents more carefully. Mr. Mercer, I want to see all communications regarding Appendix B, including delivery methods and any tracking data. Mrs. Wilson, please provide detailed records of your cancellation attempts. We'll reconvene after lunch." As the courtroom began to clear, Maggie caught whispers from the gallery. "Did you hear her cite those cases? 8 years in JAG. No wonder she knows her stuff." For the first time since entering the courthouse, Maggie allowed herself a small smile. When court reconvened after lunch, Maggie noticed a subtle shift in the atmosphere. The Patriot attorneys had multiplied. A third chair had been added to their table. An older man whose expensive suit and commanding presence suggested he was a senior partner brought in for reinforcement. Judge Garrison's demeanor had changed as well. He studied her with an intensity that suggested she had become a puzzle he was determined to solve. "Mrs. Wilson," he began without preamble, "I've reviewed your submissions. Your understanding of contract notification requirements is noteworthy, but I'd like to address a more fundamental issue." Maggie straightened in her chair. "Yes, Your Honor. Patriot's counsel has raised a matter of arbitration. Section 11 of your contract specifies that disputes shall be resolved through binding arbitration. Why are we in my courtroom at all?" It was a pivotal question, one that could end the proceedings immediately. The Patriot attorneys leaned forward expectantly. The judge's challenge hung in the air, his expression suggesting he'd found her Achilles heel. Maggie didn't hesitate. "Your Honor, I direct the court's attention to Exhibit C in my filing, the complete communication history with Patriot. On February 17th, I received an email from Patriot stating, and I quote, 'Your cancellation request has been escalated to our legal department for resolution in the appropriate venue. This constitutes a waiver of the arbitration clause under the principle established in Howard versus Faro Gas Partners.'" She pulled out the specific document and approached the bench, handing it to the judge with confidence. "Furthermore," she continued, The arbitration clause itself is unenforceable under the unconscionability doctrine as outlined in AT&T Mobility versus Concepcion. The clause requires that arbitration take place exclusively in Phoenix, Arizona, despite Patriot doing business in all 50 states and me residing in Virginia. This creates an unreasonable burden that effectively denies consumers their day in court. The senior partner from Patriot rose to his feet. Your Honor, Richard Harmon for the plaintiff. Mrs. Wilson is misapplying Concepcion, which actually upheld the enforceability of arbitration agreements. Judge Garrison raised a hand. I'm familiar with the case, Mr. Harmon. Mrs. Wilson, your response? Concepcion did uphold arbitration clauses generally, Your Honor, but it didn't eliminate unconscionability as a defense. Subsequent cases like Chaveria versus Ralph's Grocery and the Grandpa v. Mail coups have clarified that arbitration clauses can still be invalidated if they are procedurally and substantively unconscionable. Requiring a Virginia consumer to arbitrate in Arizona at their own expense meets both tests. Judge Garrison leaned back in his chair, studying Maggie with undisguised interest. Mrs. Wilson, you cite Federal Circuit decisions with remarkable precision for someone without formal legal credentials. It wasn't a question, but Maggie felt compelled to respond. I believe in being thorough, Your Honor. A ghost of a smile touched the judge's lips. Indeed. Well, in the interest of moving this matter forward, I have a proposal. This seems like a case that could benefit from mediation. I know a retired judge who handles such matters pro bono for cases I refer. Would both parties be amenable? 1 year later, Margaret Wilson sat in the front row of her military law certification course at Virginia State University. At 61, she was older than most of her classmates, but her life experience and self-education had given her an edge that impressed both students and professors alike. Her phone vibrated with a message from Sarah. Good luck on your moot court today, Grandma. Show them what a real veteran can do. As she gathered her notes, Professor Winters approached her desk. Mrs. Wilson, I hear Judge Garrison will be presiding over your moot court competition this afternoon. Maggie smiled. Yes, I'm looking forward to it. He rarely volunteers for these events, the professor remarked. I wonder what drew him to this one. As Maggie headed toward the moot courtroom, her confidence growing with each step, she had a pretty good idea. 3 days after their courtroom encounter, Judge Garrison had personally called the dean of the Veterans Legal Education Foundation, recommending her for their scholarship program. The mediation had been successful. Patriot Defense had agreed to waive the penalties, requiring her to pay only the actual service charges of $345. More importantly, Richard Harmon had offered her a part-time consulting position reviewing consumer contracts for veteran clients. Sometimes life's hardest challenges were actually doorways to new beginnings. You just had to be brave enough to walk through them. In a world quick to judge people based on appearances, remember that expertise and courage often hide in plain sight. Maggie's story reminds us that our veterans carry valuable skills that deserve our respect and recognition long after they've hung up their uniforms. Have you ever witnessed someone being underestimated because of their appearance or age? How did they prove their critics wrong? Share your experiences in the comment below, and let's respect each other's stories. If you found this story inspiring, don't forget to subscribe for more powerful tales of courage and triumph.